In this session, we begin our examination of the federal laws that apply to employment setting that prohibit discrimination and retaliation. In this session, as well as the ones that will follow, we're going to go probably a little more in depth than what you feel like we have done in some of our other discussions. And I want to do that because I feel like these are very important areas at this current time. One, there's an growing number of employment claims that are happening. And so, as you're in your jobs and you're in your fields, even if you're not in HR, if you're in management or whatever position you may be in, you may be faced with having to make some hard decisions. And when you make decisions, it's important to understand the potential implications that could happen when you terminate somebody or you deny somebody a promotion. There's a chance that someone could sue you claiming, and by you, I mean the employer, could sue the employer claiming that they were denied that promotion because it was discrimination based on their sex or their age or their race or a disability, or they may claim that they were being retaliated against because they filed a charge with the EEOC, or they participated in an internal investigation about their supervisor. For these reasons, and the growing trend of these type claims, I want you to have a greater look and um, understanding of these laws. So before we get into the laws, it's important to introduce you to the EEOC. The EEOC stands for the Equal Employment Opportunity Commission. This is a federal agency that's been given authority to receive, initiate, and investigate charges of discrimination that are filed against employers. So the EEOC is a prerequisite to filing an employment discrimination lawsuit in court. So before you can file a lawsuit alleging that you were discriminated against based on your age, you would have to file a charge of discrimination with the EEOC. The EEOC would have to investigate it, and the EEOC can decide to pursue the claim on your behalf. If they think you were discriminated against, they may take it and file the lawsuit on your behalf. Alternatively, if they look at it and they believe that there is not any merit to the claim based on what information they've gathered in their investigation, then they will issue what's called a right to sue letter. It's a notice telling the employee that they've completed their investigation and they found no credible evidence of discrimination or retaliation based on whatever the employee claimed. And it then tells the employee that you have the right to file your lawsuit in court now, and you have to file it within 90 days of receipt of that right to sue letter. So you have the EEOC, that's the federal agency, but some states have companion agencies. In Tennessee, we have the Tennessee Human Rights Commission, and they're tasked with enforcing Tennessee's analogs to these federal statutes. So what laws does the EEOC cover? Well, it covers Title VII, which we'll talk about in a few minutes, and that's race, color, sex, national origin, and religion. Those are the protected classes under Title VII. Then you have the Pregnancy Discrimination Act, which was an amendment to Title VII to make pregnancy or pregnancy-related conditions a protected class. They have authority over the Equal Pay Act, which requires that regardless of gender, that people be paid the same wage for the same work. Then you have the Age Discrimination Employment Act, known as the ADEA, and that prohibits discrimination based on age. Then you have the Americans with Disabilities Act, which prohibits discrimination based on disability. Then you have portions of the Rehabilitation Act, and then the Genetic Information Non-Discrimination Act, GINA. And we're not going to cover the Rehabilitation Act or GINA because claims under those are much, much less common than Title VII, the PDA, the ADEA, the ADA, and the Equal Pay Act. So if you have a claim under any of these federal statutes, then before you can file your lawsuit against your employer, the employee would have to file a charge of discrimination with the EEOC and give the EEOC the opportunity to investigate it and decide whether they want to sue on your behalf or give you a right to sue letter. So coverage under these statutes that we just mentioned are not automatic. Instead, employers have to have a minimum number of employees. The Equal Pay Act is the exception to this. It applies to all employers, regardless of if you have 1 or 5,000 employees, it applies to you. Title VII, the ADA, the PDA, and GINA all require that you have 15 or more employees. The ADEA requires 20 or more employees. So the Tennessee Human Rights Act, that's the state equivalent to the Title VII and the ADA. Then you have the Tennessee Disability Act, and that's the state equivalent to the ADA. And it follows the practices and requirements of the Tennessee Human Rights Act. So the investigating agency is the Tennessee Human Rights Commission. Under the THRA, it applies to employers that have 8 or more employees. So what's the relationship between the EEOC and the Tennessee Human Rights Commission? The Tennessee Human Rights Commission is charged with enforcing and investigating claims made under the Tennessee Human Rights Act and the Tennessee Disability Act. But the THRC has a cooperative agreement with the EEOC which allows each to act as the other's agent, meaning that the THRC has the authority to investigate federal claims as well, and the EEOC has the same authority to investigate state law claims. So they have basically a working agreement where if a charge is filed in the EEOC that raises state law-based claims, they have the authority to investigate those claims as well as the federal claims. And the same would be true for a charge filed with the THRC. So you have a filing timeline here that you have to do. So the employee has to file their claim within 100, they have to file their charge with the THRC within 180 days. And that 180 days is from the act of discrimination. So if it was discrimination allegedly occurred while you were being terminated, then the day you were terminated, from that day forward, you've got 180 days to file your charge of discrimination with the THRC. If you don't file it within that 180 days, then the charge is going to be, the claim is going to be stale because you didn't meet that procedural, basically it acts as a statute of limitations where you've got a short limited period of time to file in. And if you file with outside of that 180 days, if you wait 190 days to file, your charge is going to be deemed untimely and will be dismissed. In the EEOC, in states like Tennessee, where you have a state agency that's comparable to the EEOC, and they have that working agreement, then the time period for EEOC charges is extended to 300 days. So you would have to file your charge with the EEOC within 300 days of the date of termination. Again, if you file it outside of 300 days, so if it's 315 days, your claim is going to be dismissed as untimely. So, and like we mentioned earlier, filing that charge is a prerequisite to filing your lawsuit in court. If you don't file a charge with either the THRC and the EEOC and obtain that right to sue letter, your claim is going to be barred under the doctrine known as a failure to exhaust your administrative remedies. And that means that you failed to complete the procedural prerequisites that must be satisfied in order to gain access to the court system. So the agency with whom you file your charge with, if you file it with the THRC, then generally the THRC is going to investigate it. If you file a charge with the THRC and it is exclusively federal-based claims, very common for the THRC to send the charge to the EEOC for them to investigate. And that comes down to a lack of resources. The EEOC has more people to investigate, a larger organization than the THRC does. So the THRC will send the case to the EEOC simply to save them from having to do it. And so they often will defer and send it to the EEOC. Part of the EEOC and THRC process is they will encourage at the beginning the parties to engage in a mediation. The THRC conducts theirs by phone and email, and you more or less are passing offers back and forth between the THRC investigator and the parties, and it takes an inordinate amount of time to complete a mediation. In contrast, the EEOC, when they conduct mediations, you go to their office and they have a mediator and they put you in rooms and they conduct a mediation like a normal mediation would, and it's usually much more effective than the THRC process. But if the case does not settle at mediation or the parties will not agree to mediation, then the case is sent to the investigation phase, and an investigator would request documentation from the employer and the employee. They'll gather information may do interviews either on site or via telephone, and they'll complete their investigation. So once you do file your charge with the EEOC, then any statute of limitations that may apply to your federal claims are going to be told. So you won't have a statute of limitations problem as long as you filed your charge timely. But in contrast, in state court, your statute of limitations, not state court, but state law claims, the THRA and the TDA claims, they're not told while your claim is pending. So if you file the charge, your time period is still running, and you must file your claim within your statute of limitations period. So you know a little bit now about the prerequisite that you have to go through with the EEOC or the THRC to gain the ability to get to the court system. So if you're making one of these charges, it is usually one of discrimination or of retaliation. And let's look briefly at how a discrimination claim is and what a retaliation claim is and how you prove them. So discrimination is any policy or action that's taken related to recruiting, hiring, promotion, pay, or training practices that result in an unfair disadvantage to either an individual or a group of individuals who are considered part of a protected class. And when we use the term protected class, we're referring to those categories that you're prohibited from making decisions on. So you can't make a decision to not give someone a promotion because of their religion or because of their age. You can't decide, I'm not promoting Ted because he's 58. I'm going to instead promote Lisa, who's 27. That would be discrimination based on a prohibited class, a protected class. So discrimination claims are proven by either what's called direct evidence or indirect evidence, and we'll look at each. And this method of direct evidence and indirect evidence is going to apply to all the claims that we're talking about for Title VII, the ADEA, and the ADA. So this direct method of proof, this is evidence that directly establishes discrimination. So it's evidence which, if believed, requires the fact finder to conclude that unlawful discrimination was the but-for cause of the employment decision. So it leaves no doubt in your mind that the reason the adverse action was taken was because of a discriminatory reason. And so in our example of, forget his name, but the older employee not getting the job and Lisa getting the job instead, in that scenario, you would have to have evidence that would lead you to the conclusion that the only reason that the older gentleman was not given the job was because of his age. So direct evidence must establish that the employer in that instance was predisposed to discriminate on the basis of age and that they acted on that disposition. So In our example that we gave, they did act on it, and there'd have to be some evidence to establish it. So you would need a statement, such as the decision maker saying, telling someone he's not getting the job because he's too old, or he's too old for this job. That statement leaves little doubt that the reason for the adverse action, the non-selection for promotion, was because of his age, which was a protected class. So the direct evidence has to prove the existence of the unlawful discrimination without you having to make inferences or assumptions. Once you start having to make inferences or assumptions, it's not direct evidence. It would not be enough to establish that the but-for cause for the employment decision was unlawful discrimination. So if the evidence requires the fact finder to infer a fact, then it's not direct evidence. So evidence of conduct or statements by a person in making the employment decision directly manifesting a discriminatory attitude of a sufficient quantum and gravity that would allow the fact finder to conclude that the attitude more likely than not was the but-for cause of the employment decision. That's the fancy court way of saying that the person has to give some evidence that leaves no doubt in your mind that the reason they took the adverse action was because of the protected class. And if you have direct evidence, it's really helpful for the employee because direct evidence is enough to defeat summary judgment. And if you'll recall, summary judgment from our first week is where you ask the court to say, look at all the facts that are undisputed, and if you look at them, then we are entitled to judgment as a matter of law based on applying the law to the facts. And if you can defeat summary judgment, then you are going to get a trial. So direct evidence is very persuasive and very important for an employee in these type cases. So here are some examples, and we'll go through a few of these. Some are direct evidence and some are not. In a performance review, a superintendent tells the principal, the school board wants you to retire. You hear the term retire and you may think, well, that means age discrimination. Well, the cases say that that's not true because the term retire does not clearly imply that the reason that they're wanting them to retire is because of age. Because a person could have to retire based on number of years service, not necessarily because of age. The next statement is the superintendent tells the principal they just want somebody younger. That would be an example of direct evidence because that leaves little inference as to why they're taking the action. The reason they took the action is they need somebody younger than you. You're too old. So there's little doubt that the action that was taken was because of a prohibited reason. The last one here is the boss tells an employee, why don't you quit and make everybody happy? Again, it doesn't sound good, but that's not direct evidence because you've got to draw an inference that the reason they're asking you to quit is because of either age or a disability or sex or race, one of those protected classes. It doesn't clearly establish that the reason for any sort of action that's taken is because of a protected class. Here's some other examples. During a job interview, the employer's representative remarks that the applicant was an older man. That's not enough. Just saying an older man, that's a remark, but you still have to infer that because he was an older man, that he didn't get the job. And that's not clearly established in this statement. The next one, when the applicant asked why I did not get the job, the employer's representative stated that she couldn't get off the age thing. That is direct evidence because you're specifically responding and saying the reason that you didn't get the job was it's based on your age. And so if your age being a protected class, that's going to leave no having to make inferences or assumptions about the reason why the person was not hired. So under direct evidence, not all evidence or comments, even if considered bad, are automatically direct evidence. You can have what's called a stray remark. And direct evidence does not include stray remarks in the workplace, particularly stray remarks that are made by people that are non-decision makers or that are made by decision makers that are unrelated to the decisional process. So a statement that's made 2 months before the termination may be considered a stray remark, even if it's made by the decision maker. Because stray remarks are general, vague, or ambiguous comments, and they do not constitute direct evidence because the remark usually requires a fact finder to draw further inferences to support a finding of discriminatory animus. So when you see these things, these comments that may be offered as direct evidence, you've got to think, one, is it direct evidence in that does it establish the intent of discriminatory animus? Does it show that the action was taken because of a protected class? If it does, then it may be direct evidence. But you also got to consider next, is it a stray remark? Was it a remark that was made by a non-decision maker? Was it made by a decision maker but outside of the decision process? If it's a stray remark, then it's not going to be direct evidence. So you look at a few factors to help determine if it's a stray remark or direct evidence. One, you look at whether the remark was made by the decision maker or an agent uninvolved in the decision. If it's a decision maker, it's more likely that it's direct evidence. But if it's by somebody unrelated to it, then it's more likely to be a stray remark. But if it's a remark by the decision maker outside of the decision that's being challenged, then it may be a stray remark. So that factor is not necessarily dispositive, it's just one that you consider. The second one is whether the remark was isolated or part of biased comments. If it's an isolated and sporadic, it's less likely to be direct evidence and more likely a stray remark. If the remark was made close in time to the decision, the closer in time it is to the decision, the more likely it helps establish direct evidence as opposed to a stray remark. And you also consider whether the remark was ambiguous or clearly reflective of discriminatory animus. If it's more like ambiguous, then it's more likely to be a stray remark. The more clearly it reflects a discriminatory bias, discriminatory animus, the more likely it is to be direct evidence. So isolated and ambiguous comments are insufficient to support a finding of direct discrimination. But stray remarks may still be relevant at trial because they can add color, as the court puts it, to the decision-making process and to influence behind the actions taken with respect to the plaintiff. So even if it's stray remarks, that doesn't mean that the statements have no value in a lawsuit. They do. They can help at trial to just establish the attitude or the atmosphere at the employer's place of business and just help show the attitude of the managers and the decision makers. And so it can be relevant to help establish a claim, but it's not in and of itself going to establish discrimination.